This is an IEEPA Tariff Refund Recovery Public Information Campaign by Tariff Recovery Group USA. Visit tariffrecoverygroupusa.com for additional information about claiming your tariff refund or to apply for a cash advance on a claim that you have already filed. If your business raised prices in 2025 because of the increased import tariffs, and now you are planning to claim a refund on those same tariffs, there's a chance that decision could get you sued by your own customers in one of the class action disputes that are emerging over this exact issue. Your customs broker has no way of telling you whether or not you're at risk. This isn't just hypothetical. Legal disputes over this are already emerging between importers and their own customers who effectively paid those tariffs in the form of higher prices. The problem is that if your broker is the one reviewing your entry history, anything they find isn't legally protected from discovery. Instead, your import entries are treated just as if they were normal business records, making them fully discoverable if this issue were to ever affect you. In this short video, I will explain why the risk of a class action lawsuit exists and how to determine your own specific exposure to this risk by using the one type of import entry history review, which, when performed under strict attorney-client privilege, can actually tell you whether you're exposed, but without creating a discoverable paper trail in the process. Why does it matter whether it's an attorney or a customs broker that reviews your import entries for your tariff refund claim? Brokers cannot protect your entry history review under attorney-client privilege. If a broker goes through your past entries and finds something misclassified, such as goods filed under the wrong code, which is more common than you may realize, that now becomes legally discoverable, meaning that a CBP audit can access it. Brokers also cannot evaluate your class action exposure. There's litigation already emerging that targets companies that passed import tariff costs onto their customers and are now also claiming a refund. A broker has no way to assess that risk for you, but an attorney can. Because attorney-client privilege only applies to attorney communications, the same review, done by an engaged customs and trade attorney, is privileged and therefore legally protected. This distinction matters enormously if your import entry history has any sort of complexity, and it matters most if you raised prices in 2025 in response to tariffs as class action lawsuits begin to emerge. Having attorney-client privilege means being legally protected from it all. So what does this all mean, and how does it affect you right now, in practice? If your broker reviews your entry data and HTS codes, that review can be pulled in an audit or in litigation. When an attorney does the exact same review, it can't be subpoenaed. This matters most if any of your goods might have been misclassified, which can cut one of two ways. Either you overpaid, which could mean receiving a bigger refund, or you underpaid, which could lead to a compliance bill that CBP can collect on with interest. This is why you want everything to first be looked at under privilege before anything is filed, so you can know with certainty. Let's bring this all together now in a very quick recap. If you raised prices last year because of the increased tariff costs, and now you're planning to claim a refund of those same tariffs, this is a conversation worth having first, before you file, and certainly before your customs broker goes through any of your import entry history. None of this means that you should not file your refund claim through your trusted import broker. You just need to understand the legal limits of their ability and authority, and to understand when you may need more legal protection, capability, and experience in dealing with U.S. customs and trade law. And you need to know all of this before you file your claim. Finding out after will be too late. If you imported goods subject to IEEPA tariffs between February 2025 and February 2026, you likely have a legitimate claim. Filing windows are closing. The first step is independent assessment of your complete import history, not just the entries that happen to be easiest to process, so you can know now if an attorney is needed to recover your full tariff refund. This has been part of an IEEPA Tariff Refund Recovery Public Information Campaign. For all the up-to-date information about how to collect your refund of unconstitutionally collected IEEPA tariffs and to check if your business qualifies, visit tariffrecoverygroupusa.com, where you can file your valid refund claim today with the full backing of an independent, nationally ranked U.S. Customs and Trade law firm. There is no upfront cost to file your claim, and if you have already filed, regardless of how the filing was done, we offer a way to get a cash advance on your refund within just 5 to 10 business days, not by waiting months or years. Check your eligibility for free and without obligation today at tariffrecoverygroupusa.com. It costs nothing and takes only a few minutes. Link in the description and pinned comment.